I'm so disappointed with how today started. It started with a lecture, okay? Like going into your university class and, your lecturer's right there, ready to go, quoting case this and that. Today, you're quoting this today? When the witness yesterday tried to walk out, you said absolutely nothing. Why did you not have this conversation yesterday? I know you wanted to prepare it and type it out and put in your case studies. No problem. You could have come back with a tidied up version today. Why did the witness leave the courthouse yesterday knowing you got his back? That was unfair, that was uncalled for, and unnecessary. The defense are all qualified legal attorneys, okay? Advocates. They're not even attorneys. Because you said address people by their surname. That's going to be hard for me because I prefer saying Pinky because I can't say her last name, but I digress. You said address them by their ranking, their surname, and also by, almost said job description, by their title. So, you know what? I'm going to try moving forward in my videos. I think that's a fair request. I apologize to Pinky in advance. I cannot say your last name. Number 3, what else do I want to say? I've even lost track of what I wanted to say. But I really wanted to start this video off by giving how I feel about it. The next parts of the video, of course, is going to highlight what Judge Ratha said. But in my opinion, I think this was unfair. But let's listen to it because there's some important points that Mnisi is going to pull apart later in a separate video. Mnisi is going to pull them apart in a separate video. I really, the judge should have, if his intention was non-biased, should have addressed this yesterday, put the laws of the land, the decorum in his courthouse yesterday. But let's listen in to what he has to say. I'm not sure if I'm going to keep it as it is or I'm going to cut off some parts. It is interesting. Yeah, let's catch up. I'll be back with the rest of my commentary.
Yeah, there are some remarks which I want to state before we start. These arise from the fact that yesterday any intelligent person could have seen that the proceedings yesterday, they left much to be desired. And further that when we concluded or postponed the matter, it was obvious that there was acrimonious exchange between this Colonel Steyn and Advocate Mnisi. And I thought it is proper, as a presiding officer, in adjudicating this matter, to set down the principles which govern the concept of cross-examination and the response from a witness and the question asked by counsel. Unfortunately, these are the precepts, regulations, concepts, customs, and conventions which apply until maybe, as people are saying, we change the law in South Africa into what people are calling African law. But unfortunately, the law as it obtains today is formulated under our Constitution and even under our Criminal Procedure Act, which we all know was written by Yemstra initially. We used to use Wigmore, who's an English jurist, but subsequently the late Judge Yemstra coordinated these laws and drafted what was referred to as the Criminal Procedure Act, which, as I say, incorporates a modicum of how cross-examination should be conducted and how a witness should be treated, how counsel should be treated, and how court officers should exercise decorum in this court. Normally these things are said at the end of the case, when a court is writing its judgment. I've used in this context Wigmore on criminal law, Detroit, and Himstra, and I've summarized what they have to say about the conduct of cross-examination in a court of law. You'll interpret after I'm finished, okay? It is tried that in terms of section 166, a witness may be cross-examined. But cross-examination in terms of the Criminal Procedure Act and in terms of section 35 of the Constitution is not an absolute right. It's not an absolute right. Like all rights in our Constitution, they are limited by set exigencies. The authors basically say that it is a right of an accused person through his counsel to cross-examine a witness who is called by the state, but then the injunction is that the court will of course guard against inadmissible questions. And they say that the substance of the questions is important, not mere words. Even tone of voice can transform an apparently proper question into an improper one. And then they quote the case of Schmidt. They quote Schmidt, who's a writer. And they also quote the case of S versus Aitken, and another 1988 4 SA 394 at 397E is a Cape case. And they say the paragraph in Wigmore referred to the uses or the usual sources of the reference in this regard, where they are saying that even a question which is innocuous, depending on the tone in which it is said, uttered, or stated, it may be improper, or it may become improper. The purpose of cross-examination is to discover the truth. It is accepted in our criminal procedure as a test without equal for the value of oral evidence, even if it is sometimes wrongly used and even abused by legal practitioners. And it's not me saying that, I'm reading from a book. I'm not the law, I'm reading from the book.
Did you just see that dagger he gave Mnisi? You know what? Why was this not done in chambers? Why was this not done in chambers?
In S versus Steyn, 1965 1 SA 82A, which is the leading case in South Africa regarding cross-examination, conduct, mores, decorum, and dignity. It is therefore grossly unfair not to allow cross-examination. It is also irregular not to allow cross-examination, especially for unrepresented accused, within limits of fair cross-examination. Cross-examination is expressly not limited to topics raised in evidence in chief. In a criminal case, within the standards of reasonable doubt and trustworthiness, it is often more important and at the same time more difficult to expose honest witnesses may make mistakes. The law of procedure allows cross-examination great latitude to investigate any relevant topic. But cross-examination should never degenerate into a heated quarrel. Cross-examination does not mean examining crossly. The questions always retain objectivity and professionalism as an officer of the court. For instance, a simple thing like the dignity of a witness, it has to be preserved. And even our Constitution talks about dignity in Section 10. This witness, he's a colonel. He's Colonel Steyn. He must be addressed as such. And it is not me saying that. It is the law. When a doctor comes to give evidence in court, you refer to that person as Dr. So-and-so. And I've heard advocates in this court telling witnesses, hey, I am an advocate. They're correct to say that. Even under the apartheid government, when Mandela, the president, was giving evidence in the case of state South African Rugby Union in 1995, I think, when he was called by Judge Viljoen, they called him President Mandela. That judge, although he was not of the same sound opinion as Mandela, he still referred to him as President Mandela. So this witness in this court, he is Colonel, and I'm not saying this facetiously, he is addressed as Colonel Steyn. When he gave evidence in this court, he was referred to as Colonel Steyn. When House gave evidence, he was also referred to as a Lieutenant Colonel. That's what the law says. And this is categorized under what they call courtesy, the requirements of courtesy. In HIMSRA, page 166. The question may never go outside the bounds of, the questioner may never go outside the bounds of decency. Where the limits may differ from one witness to the next, but courtesy is always expected from an officer of the court, like advocates, even the judge.
This week, Judge Ratha has worked overtime to impress me, and I'm very, very happy that he's reading this into the record. Why am I happy? Because, you see, when you point your finger at somebody else, so I'll demonstrate it. When you point your finger at somebody else, that one finger, the judge is pointing at Mnisi. The four other fingers, Judge Ratha, are pointing at yourself. So I just have a bad question, just a small question, Honorable Judge Ratha, okay? Are you courteous in your own courtroom? Do you carry a courteous decorum when you speak to the advocates, especially the defense attorneys? We do know you're capable. That one we know because we see it when you talk to the state and we see it when you talk to the witnesses. Moreover, a witness who's a mlungu, okay, there's a huge difference. It's like there's a certain hierarchy of courtesies that you provide. My only question is, can you just do it uniform? Exactly the sentence you just read, but read it again now to yourself and then exercise that behavior in court every day. That's all I got to say. You know what? I would be so grateful if now moving forward when I watch, I feel you're a courteous judge. Right now, it is not a word I can use to describe to describe you at this present time. But let's continue on.
Furthermore, courtesy costs nothing, and practitioners owe it to the court and every witness. You can see the case of S versus Azau, 1974. One, the dignity of a witness may never be ridiculed. See in this respect S versus Steyn, 1988, 1 SA 851 Cape. The courts warned against the tendency of cross-examiners to sneak in personal opinions on the witness's credibility, including crude variations such as, "Now you are lying." Not only is behaving in an insulting manner towards a witness an abuse of the right of cross-examination, it is also a contemptuous assumption of the court's function as sole arbiter of credibility. The cross-examiner should never tell a witness that he or she will argue at the end of the case that the witness' answer should be rejected for the reason explained to the witness in putting the question. Everyone is entitled to be addressed by his or her surname and title in court. The use of forms of address such as witness, accused, etc. are disapproved of. You can see this, the case of S versus Gwebu, 1988, and also the case of S. Gulaqe, 1991 SACR 101A at 103F. It is simply not acceptable to address an adult by his or her first name. In Tswai, the court pointed out that especially the humble amongst us should be treated with respect and understanding, with respect and correctly and timeously admonition or timely admonition. Fairness. The cross-examiner may never exceed the limit of fairness. This applies to all cross-examination. Even the prosecutor is admonished that he should guard against excesses, particularly when an accused is not legally represented. In the case of S versus Ntshoni, 1987, cross-examination of some accused affected the fairness of the trial and the other accused to such an extent that several convictions were set aside in review. In S versus Nkabinde, 1989-2 SA 421, a conviction was set aside because of, inter alia, the irregular manner in which the accused was intimidated, insulted, ridiculed, belittled, and confused in cross-examination. The failure by the magistrate, even the failure by this judge, to stop the unfair cross-examination was found to be fatally irregular. In Mzansi, it was also stressed that a presiding officer should repeatedly, if need be, stop unfair questioning or statements to witnesses that a presiding officer finds inappropriate. And it was also stressed that a presiding officer should repeatedly, if need be, stop unfair questions or statements to witnesses. Unfairness, of course, does not only mean the type of violations mentioned above. Inaccurate statements, for instance, concerning the other witness, are also unfair. What is more, muddled the search for truth. That's what they do. Elaborate vaguely formulated two or more multifaceted and argumentative questions perhaps cause heat but shed no light. Above all, such questions are unfair to the witness, especially when a person who uses the shotgun method of questioning, who is so keen to accuse the confused witness of evasion. Cross-examination is not meant to be a test of stamina. I once said this. See in this regard Africa Solar Pty Ltd, Diwadi Pty Ltd, 2002. Fairness also requires that the owner of a witness not be attacked in argument when there is no opportunity in cross-examination from him or her to react to such accusation. They quote the case of President of the Republic of South Africa and others versus South African Rugby Football Union and others, 1999-10. It's a constitutional court case, 2000 SA, at paragraph 61 to 63. And they also quote the case of S versus Buzak, 2003 SA 381 SCA, at page 51 to 54. Honesty. Obviously, the cross-examiner may never cross the limits of honesty. A witness may not be misled. No untrue statement may be made to a witness. Statements as to what other witnesses might have said must be accurate. If a cross-examiner is not certain whether an allegation by another witness has been correctly remembered or recorded, he may or she may not put it to the witness before clarifying same. Questions may not be formulated in such a manner that they appear to be statements of fact that witnesses made, where such so-called facts do not form part of the cross-examiner's case and will not be given in evidence. The other issues I'll go to inadmissible evidence. Cross-examination based on inadmissible evidence is not permitted. Examples of such inadmissible evidence are a confession which was excluded, for instance, as being inadmissible, etc. Inadmissible evidence may also not be introduced under the cloak of cross-examination. And they quote the case of S versus Nkwanyana, 1978, 3 SA 404 Natal. And then they talk about principles under cross-examination. A trial is not a scientific experiment where certain reactions lead to exact results. It is a fallible process which attempts to form a view with reasonable confidence. Cross-examination, an aid in that process, employs several methods to test reliability of factual findings. One such method is to weigh the relative merits or different versions of fact against each other by bringing them into confrontation with each other. And they also talk about curtailment of cross-examination. And this is Himstra. General curtailment of cross-examination. It is a fact of life that protracted and apparently irrelevant cross-examination is a problem with which the presiding officers have to contend with. On the one hand, cross-examination is an indispensable component of the criminal process to advance reliable adjudication of facts, which, for reasons of principles and pragmatism, is entrusted to the parties. In an accusatorial process, the parties decide which evidence to present to the adjudicator of facts, meaning the judge, whether in writing or orally or in cross-examination. This is their right and duty. They may have information at their disposal of which the presiding officer was not knowledgeable or has no knowledge of, which she would in all probabilities would otherwise never have had. The parties may have the aim with their questions about which the presiding officer knows nothing and does not need to know. To a large extent, therefore, the presiding officer has to depend on the parties regarding the presentation of evidence. Here they warn judges that the measure is not about boredom or impatience of the judicial officer, irrespective of how prolix and even apparently misplaced a cross-examination may test a judicial officer. Irrelevancies can always be ignored afterwards. On the other hand, one can only speculate about the possible importance of particulars which remain unhidden in the proffering of the evidence. It certainly does not mean that boundless cross-examination is allowed. Where the credibility of a witness clearly is not in issue, the question may certainly be asked that is intended, of what is intended. In the absence of convincing explanation, curtailment will be in order. Also, if the court is, after judicial consideration, considering granting the right to explain the purpose of the questioning, and is convinced that one or more of the factors mentioned in Cele are present, an appropriate absolute limit may be set. They repeat again that cross-examination is not meant to test stamina. Although the court can intervene against cross-examination, the only apparent purpose of which is to tire the accused or a witness, curtailing cross-examination which is intended to traverse again evidence which already given may constitute an irregularity. Like this witness. This witness was called here, as I proposed, in a circumscribed fashion. 3 issues he had to enunciate. I won't mention what other cross-examination he was taken through. This may be interpreted as amounting to the gagging of the defense. For instance, in S versus Ngogula, 1979, 1 S8 3525 in the Transkei. The conviction was set aside because the magistrate did not allow the accused to ask questions about something the latter had said in his evidence in chief. The trial court may, however, prevent unnecessary repetition. If you see, this case is S versus Green, 1962, 3 SA 886, Appellate Division. This case was written by Falam, who conducted the Americana inquiry. He was in the SCA, retired. Once it has been determined that a certain question or line of questioning is irrelevant, it must be prohibited. If, for instance, an accused wants to go through notes in a state witness's notebook which have nothing to do with the case, it is irregular for the court to refuse to allow such a diversion. The court, questions by the court may intervene at any stage with questions for elucidation, but must not take over the role of the questioner.
And here's another one. The court is pointing a finger, but my question is the court aware of his tendency to take over the role of the questioner? For example, his tendency to talk over the defense when they are still talking and trying to put across a point and putting words into their mouth. You know, this selective reading of the Bible is just absolutely hogwash, because there are parts he leaves out. Have you noticed? He reads, and then he stops when it's now getting to a part he doesn't want us to hear. It is very selective reading. It's like the people who read the Bible, okay, and only want to quote a verse that exonerates them, okay? But let's continue on. This is almost over. Let me know in the comment section your thoughts down below about Judge Ratha descending into the arena, being the prosecutor. He says no, can intervene at any time.
The court must not ask leading questions to strengthen the state's case. I was accused the other day of colluding. In R versus Lopsha, 1926 AD 276 at 281, at R versus Ngobo, 1925 AD at 561. This is where they talk about judges who take over and become prosecutors. However, leading questions as such are not irregular if they are not put evenly at the end of the mutual questioning. Persistent and searching leading questions by the court to an accused may, on the other hand, be a factor which together with other amounts to an irregularity. In the case of R versus Bartman, 1993 SA 535A, where they talk about the fact that the court must not conduct in questioning in such a manner that its impartiality can be doubted. The court must not take part in the case to such an extent that the court obscures the points in issue. The court must not intimidate or upset a witness or the accused to such an extent that the answers are weakened or credibility degraded. And this applies also to the defense counsel. This witness yesterday wanted to get out of court and leave. I don't know why he did it. He didn't do it. And Mr. Mnisi sat down and said, "You can go." It's a court of law in South Africa. Although the court is entitled to follow its own line of inquiry, which leads to the end of the case, a conviction, or as was stated in the Clerk 1930 AD 308, the presiding officer should not get involved in lengthy questioning of cross-examination and certainly not in instructing the prosecutor or even the defense how to run the state's case or their case. That's why yesterday I gave certain of my colleagues here the case of S versus Cooper, because I didn't want to intervene and say that question is irrelevant. Read S versus Cooper, 1976. It tells you about what is irrelevant or not irrelevant. And it talks about the proximate or utmost questions you can ask concerning a particular aspect. Further, they say in the case of Kabela that impartiality, judicial fairness, and dignity should be the hallmark of judicial proceedings, to avoid that the proceedings are tainted by impropriety. Dalinjevo, supposedly some chief or king in the Eastern Cape, 2016 1 SACR 9, SCA. And they also address this question about the court itself may call a witness in terms of 167 or 186, which I addressed the other day. But it's important just to mention that they say that where the court has called a witness in terms of 167 or 186, it is not said that the court will be allowed to cross-examine such a witness. The court is not allowed to cross-examine any witness. Although it is not said which party will be allowed to cross-examine on what basis of the leave will be granted or refused, it is submitted that both questions will be answered on the grounds of fairness. In other words, the party for whom the witness is unfavorable will be granted leave to cross-examine. Like I said, this witness, if he's called here, where the state was accused of bringing evidence through the back door, and I quoted a case here which related to Judge Seriti, who refused to call a witness when an application was made by the state that this witness must be called to explain and elucidate certain aspects of the evidence. And he refused. And it was held that by the SCA, not me, Carol Lewis was one of the judges who wrote the judgment, that where a judge refuses to call such a witness, he errs. But not only does he err, he commits an irregularity. But not only is that irregularity which he commits, that irregularity is so gross or grave that it impinges on the administration of justice, or it impinges on the fairness of the trial. Because as we know, not all irregularities vitiate a trial, not all. I can commit 20 irregularities. It doesn't follow that justice has been denied to a particular litigant. It is only when the irregularity is so gross that it impinges on the fairness of a trial, and that the administration of justice can be said to have not happened. So those are the remarks. There are others. I didn't sleep. I read this whole book last night because I was worried about the conduct which happened in this court. And it's not me saying that. There must be decorum in court. A witness must be accorded the space and the dignity and a witness also has to answer to the best of his ability all the questions asked. And all of us must show each other respect, decorum, and deference, because we are all about the same thing here. We want the truth to come out of any case which we handle. Okay, thanks.
And that, ladies and gentlemen, concludes the reading from the book of Judge Ratha and the book of Judge Ratha, Court Decorum Guidelines. If you've made it this far in the video, you already know you are a graduate. No, not just a graduate. You have been ordained with a master's degree in Court Decorum. Let me know in the comment section what you have learned from today's reading, okay? That is it from me today. Please remember to like, comment, and subscribe. More videos coming your way, so don't miss it. Thanks for watching.